Tonight, we examine a case that once occupied the attention of an entire county and then slipped quietly into the historical record. A single investigation, a single file, a case that history very nearly forgot. The case of Sarah Millson begins in the City of London in the spring of 1866. The City of London in that year was the commercial heart of the British Empire. A square mile of counting houses, warehouses, and trading firms that conducted business with every corner of the globe, and within that square mile, Cannon Street stood as one of its busiest thoroughfares. Cannon Street in 1866 was lined with the premises of merchants and tradesmen whose goods passed through London on their way to markets across Britain and beyond. Leather was among the most significant of these trades, and firms such as Messrs Bevington and Sons occupied substantial premises along the street, receiving hides and finished leather goods, storing them in packing cases within their warehouses, and dispatching them onward to buyers throughout the country. The street by day was crowded with drays and handcarts, with clerks moving between counting houses, and with the general commercial traffic of a city that considered itself the financial capital of the world. By night, once the merchants had closed their premises and departed for their own residences, Cannon Street grew comparatively quiet, lit only by gas lamps, its warehouses left in the charge of caretakers and live-in staff who remained on the premises to guard the goods stored within. It was common practice among city trading firms of this period to retain live-in domestic staff, often a housekeeper and one or more servants who resided within the commercial premises themselves, rather than in separate lodgings. This arrangement served a dual purpose. It provided for the daily maintenance of the premises, the cleaning, the cooking, and the general domestic order expected of a respectable firm, and it provided a measure of security for goods that might otherwise have been left unattended overnight. A housekeeper in such a position held a role of some trust and responsibility, answerable to the partners of the firm for the good order of the premises in their absence. It was within this arrangement that Sarah Millson lived and worked in the spring of 1866. The surviving record does not establish Sarah Millson's date of birth, her place of birth, or the names of her parents. No account of her early life, her upbringing, or her education has survived among the sources examined for this case. What is documented is that she was a widow by the time of her death, and that she had been married on more than one occasion. Her first husband is understood, according to the fullest surviving account of the case, to have deserted her, leaving her without the support of a husband, and, in the eyes of the law, still married to a man who had abandoned her. It was this circumstance that is understood to have led her into a second marriage, one contracted while her first husband remained, so far as the law was concerned, still living and still her husband. Such a marriage, entered into while a previous union remained legally undissolved, constituted the offence of bigamy under the law of the period, regardless of the circumstances that had led to it. No record survives of the identity of the man Sarah Millson married in this second union, nor of his occupation, nor of what became of him. The name by which she was known at the time of her death, Millson, is the name recorded in the National Archives catalogue description of the case and in the fullest narrative account, and it is the name used throughout this account, though the precise history behind it cannot be fully reconstructed from the sources available. By 1866, she held the position of housekeeper at the premises of Messrs Bevington and Sons on Cannon Street, a position that placed her in a household of some standing within the city, responsible for the domestic management of the firm's premises and sharing that live-in arrangement with at least one other member of staff, a young woman named Elizabeth Lowes. Nothing in the surviving record describes Sarah Millson's temperament, her habits, or her standing among her neighbours and acquaintances. The record permits only the observation that she occupied a position of trust, that she had been married more than once, and that the circumstances of her second marriage left her in a position of some legal and personal vulnerability, a vulnerability that would come to bear directly on the events of the 11th of April, 1866. If you find value in histories preserved this way, consider liking the video and subscribing to the channel. Let me know in the comments where you're listening from. This story begins in an ordinary household, much like countless others across the City of London in the spring of 1866. By the early months of that year, Sarah Millson's position within the household of Messrs Bevington and Sons appeared, to all outward observation, secure and unremarkable. She carried out her duties as housekeeper, maintaining the domestic order of the premises, and she shared her living quarters with Elizabeth Lowes, the other servant retained by the firm. The two women's daily routine followed the pattern common to live-in domestic staff of the period, rising early to prepare the premises for the arrival of the firm's partners and clerks, attending to the household tasks required to keep the residence portion of the building in order, and remaining on the premises through the evening hours once the commercial day had concluded. Beneath this outward stability, however, Sarah Millson was subject to a source of considerable private pressure. According to the fullest surviving account of the case, a man known as William Smith, called Bill Smith, had for some time been in the habit of extorting money from her. The precise nature of the leverage he held over her is not fully settled in the sources examined. The fuller and more detailed account attributes his hold over her to the circumstances of her bigamous second marriage, suggesting that Smith threatened to expose the irregularity of her marital situation unless she paid him. A secondary account frames the pressure differently, suggesting instead that Smith pursued her over an old debt, a sum of money he claimed she owed him from an earlier arrangement between them. Both explanations appear among the sources reviewed for this case, and the precise mechanism of the pressure Smith exerted upon her cannot be established with certainty. What can be stated is that a financial and personal pressure existed between Sarah Millson and William Smith in the period leading up to her death, and that this pressure would come to occupy a central place in the subsequent investigation. A woman in Sarah Millson's position, holding a bigamous marriage that had never been legally regularized, occupied a precarious standing under the law of the period. Exposure of such a marriage carried the risk of social disgrace, the loss of a respectable position such as the one she held with Messrs Bevington and Sons, and potential prosecution under the criminal law governing bigamy. A person aware of such a circumstance held, in effect, a measure of power over the person whose secret they knew, and it was this kind of power that the surviving record suggests William Smith held, or claimed to hold, over Sarah Millson in the weeks before her death. The evening of the 11th of April, 1866, began as an ordinary evening within the household. Sarah Millson went about her usual housekeeping duties within the premises of Messrs Bevington and Sons. Elizabeth Lowes was elsewhere within the building, upstairs from the hall and stairway where Sarah Millson was occupied. The weather that evening was marked by heavy rain, a detail recorded in connection with an incident that occurred at some point during the hours before the household retired. A woman, never subsequently identified, was observed sheltering from the rain on the doorstep of the premises. When invited to come inside out of the weather, she is recorded as having demurred, replying, in words preserved in the account of the incident, that she could not come in before moving off into the wet evening. This woman was never traced, and her connection, if any, to the events that followed was never established. The detail survives in the record as an unresolved and unexplained feature of the evening, not as a confirmed element of the crime itself. At some point after this incident, within the same household and on the same evening, Sarah Millson was struck about the head with considerable force. The precise sequence of events between the sighting of the unidentified woman on the doorstep and the discovery of Sarah Millson's injuries cannot be reconstructed from the surviving record. What the record does establish is that a little after 10 o'clock that evening, Elizabeth Lowes descended the stairs within the premises and came upon Sarah Millson at the foot of the staircase, suffering from severe wounds to the head. The blood from her injuries was, according to the record, still flowing at the moment of discovery, a detail that investigators would later take to indicate that the attack had occurred only shortly before Elizabeth Lowes found her. The alarm was raised within the household immediately upon this discovery. Given the severity of the injuries observed, and given that the premises lay within the jurisdiction of the City of London, the matter was brought without delay to the attention of the City of London Police, a force distinct from the Metropolitan Police that governed the districts surrounding the city itself. The investigation that followed would occupy the attention of that force for a considerable period, and would eventually bring one man before the Old Bailey to answer for Sarah Millson's death, though the outcome of that trial would leave the question of who was responsible for her death formally unresolved. The circumstances surrounding Sarah Millson in the weeks and hours before her death, taken together, present a household outwardly ordinary and a woman outwardly secure in a position of domestic trust, set against a private history of marital irregularity and financial pressure that the investigation would come to regard as central to establishing a motive for her murder. The detail of the unidentified woman on the doorstep, never explained and never resolved, would remain one of the case's most enduring points of mystery, recorded in the file but never connected with certainty to what followed. The discovery of Sarah Millson at the foot of the staircase marks the point at which an ordinary household evening became a matter for the police. Elizabeth Lowes, finding her fellow servant grievously injured and the blood from her wounds still fresh, raised the alarm within the premises without delay. Word was carried to the City of London Police, whose officers arrived at the Cannon Street premises to find a household disturbed and a woman who did not survive her injuries. The record establishes that the household staff and any others present that evening were required to remain available to give an account of the evening's events, a standard procedure in cases of sudden and violent death within the city's jurisdiction. The investigation into the death of Sarah Millson was formally opened by the City of London Police in the days that followed the discovery. Officers were dispatched to examine the premises of Messrs Bevington and Sons in detail, beginning with the stairway and hall in which the body had been found. The investigation proceeded on the understanding that the attack had taken place within the premises themselves. Given that Sarah Millson had been found at the foot of the internal staircase, and that no evidence suggested she had left the building that evening. Officers examined the immediate vicinity of the discovery for any object that might have served as the weapon used in the attack. Among the items recovered during this examination was a small crowbar of the type commonly kept within a leather warehouse for the purpose of prizing open packing cases containing hides and finished goods. This particular crowbar was found near the position in which Sarah Millson had been discovered, but was found to be unstained by blood, indicating that it had not been the implement used to inflict her injuries. A search of the premises subsequently established that a second crowbar of similar type, and kept for the same purpose, was missing from its usual place among the firm's tools. Investigators concluded that this missing implement was the more probable weapon, and that it had been removed from the premises by whoever had committed the attack, a conclusion that carried the further implication that the person responsible had taken care to remove the weapon rather than leave it at the scene. A further detail noted by investigators during their examination of the scene concerned Sarah Millson's shoes. These were found not upon her person, but removed and placed upon a table within the hall, and it was further noted that no blood was found upon them. This detail was recorded at the time as puzzling, and no explanation for it was established during the course of the investigation. Officers considered various possibilities, including that the shoes had been removed by Sarah Millson herself prior to the attack, or that they had been removed afterward by another party present in the building, but the surviving record does not indicate that either possibility was resolved with any certainty. The detail was entered into the investigative file as an unexplained feature of the scene and was never subsequently accounted for. Officers also turned their attention to the account of the unidentified woman observed sheltering from the rain on the doorstep of the premises earlier in the evening. Household members were questioned as to whether they recognised this woman or could offer any description beyond what had already been recorded. No identification was ever made, and the woman was never traced by the investigation, despite what the record indicates was some effort directed toward establishing her identity. She remained, throughout the investigation and afterward, an unresolved figure in the case, her presence on the doorstep noted but never connected with certainty to the events that followed inside the premises. The investigation's most significant development concerned William Smith, known as Bill Smith, whose prior financial dealings with Sarah Millson had already made him a figure of interest before the attack took place. Investigators established, through inquiries made in the course of their work, that Smith had for some time been extorting or otherwise pressuring Sarah Millson for money, whether in connection with her bigamous marriage or in connection with an old debt. The two explanations for his hold over her both being recorded among the sources examined for this case, without either being conclusively preferred over the other by the investigation itself. This history of financial pressure was taken by officers to supply a plausible motive, and Smith accordingly became the principal suspect in their inquiries. A witness came forward during the course of the investigation who stated that she had seen a man leaving the vicinity of the Bevington and Sons premises on the evening in question, and who subsequently identified that man as William Smith. This identification became a central plank of the case that investigators built against him. It later emerged, however, and was raised as a significant point at his trial, that this witness had received assistance from police officers in the course of making her identification, a circumstance that cast considerable doubt on the reliability of the identification, and that was subsequently criticised, both at the time and in later retrospective accounts of the case, as a serious flaw in the conduct of the investigation. Contemporary commentators and later the historian Jan Bonderson, in his account of the case, pointed to this flawed identification procedure as a central reason the prosecution of William Smith ultimately failed to secure a conviction. On the strength of the motive supplied by his history of extorting Sarah Millson and the witness identification placing him near the premises, William Smith was arrested and brought before a magistrate, who committed him for trial at the Old Bailey on the charge of her murder. No other named suspect emerges from the sources examined for this case, and the investigation, once it had settled upon Smith as its principal object, does not appear to have pursued alternative lines of inquiry with the same vigour, a pattern that later commentary has suggested may have narrowed the investigation prematurely and contributed to the case ultimately remaining unresolved. The investigation into the death of Sarah Millson thus proceeded from the examination of the physical scene, through the identification of a probable weapon and the recognition of several unexplained details, to the development of a single principal suspect on the strength of motive and a contested identification. It concluded with the committal of William Smith for trial, a proceeding that would test the strength of the case the City of London Police had assembled against him, and that would ultimately expose the weaknesses within it. The examination of Sarah Millson's body was conducted in the days following her death, as was standard practice in cases of sudden and violent death within the City of London's jurisdiction. The examining physician who conducted this post-mortem examination is not named in the sources reviewed for this case, and the specific findings recorded during the examination have not survived in detail among the materials available. What is established is that the examination confirmed the injuries to Sarah Millson's head to have been severe, that they were consistent with having been inflicted by a blunt implement of the type represented by the missing crowbar, and that the injuries were determined to be the direct cause of her death. The physician's findings were consistent with the circumstances observed at the scene, namely that Sarah Millson had suffered a rapid and fatal assault, and that the blood still flowing from her wounds at the moment of discovery indicated the attack had occurred only shortly before Elizabeth Lowes found her. The examination did not, so far as the surviving record indicates, identify any additional circumstances, such as evidence of a prolonged struggle, or evidence that more than one implement had been used, beyond what had already been observed at the scene of the discovery. The post-mortem findings were entered into the record maintained in connection with the case, and were subsequently placed before the coroner's inquest convened to inquire into the circumstances of Sarah Millson's death. The medical evidence, establishing both the cause of death and its likely timing, formed one part of the foundation upon which the subsequent inquest and criminal proceedings were built, though the examining physician's testimony does not appear, from the sources available, to have been a point of significant contention at any later stage of the proceedings. A coroner's inquest was convened in the aftermath of Sarah Millson's death, in accordance with the standard legal requirement that a sudden and violent death be formally inquired into before a coroner and jury. The inquest examined the evidence gathered by the City of London Police, including the medical findings as to the cause of death and the physical evidence recovered from the scene, among which the crowbar found near the body and the missing second crowbar featured prominently. The precise identity of the coroner who presided over this inquest, the exact dates on which it sat, and the full roster of witnesses called before it have not survived in the sources examined for this case, and the record permits only a general account of its proceedings and conclusions. The inquest jury heard evidence establishing that Sarah Millson had died as a result of severe head injuries inflicted by a blunt implement, most probably the missing crowbar, and that the attack had taken place within the premises of Messrs Bevington and Sons on the evening of the 11th of April. The jury also heard evidence concerning the unexplained circumstances surrounding the case, including the removal of Sarah Millson's shoes and their placement, unstained by blood, upon a table within the hall, and the sighting of an unidentified woman sheltering from the rain on the premises doorstep earlier that evening. Neither of these details was resolved during the course of the inquest, and both were entered into the record as unexplained features of the case. The inquest proceedings also touched upon the financial pressure that William Smith was understood to have exerted upon Sarah Millson prior to her death, evidence that was considered relevant to establishing a possible motive for the attack. Though the inquest's function was limited to determining the cause and circumstances of death rather than to establishing criminal responsibility. Following its examination of the evidence before it, the inquest jury returned a verdict consistent with the case proceeding to a criminal prosecution, a finding that paved the way for the magistrate's committal of William Smith for trial at the Old Bailey. The inquest into Sarah Millson's death, though limited in the detail that survives concerning its specific proceedings, established the essential facts upon which the subsequent criminal trial would rest, namely the cause of death, the probable weapon, and the general circumstances of the attack, while leaving several of the case's more puzzling details formally unresolved. It closed with the matter referred forward into the criminal courts, where the question of responsibility for Sarah Millson's death would be tested before a jury under the full rigour of a criminal trial. The trial of William Smith on the charge of murdering Sarah Millson commenced at the Old Bailey, the central criminal court holding jurisdiction over offences committed within the City of London. The exact date of the session, together with the name of the presiding judge and the counsel engaged on either side, have not survived in the sources examined for this case, and the record permits only a general account of the proceedings and their outcome, drawn from the fuller narrative treatments of the case rather than from a direct transcript of the trial itself. The prosecution's case against William Smith rested upon two principal foundations. The first was the history of financial pressure he was understood to have exerted upon Sarah Millson in the period before her death, whether connected to her bigamous marriage or to an old debt between them, a history the prosecution presented as furnishing Smith with a clear motive for wishing her harm. The second was the testimony of a witness who identified Smith as a man she had observed leaving the vicinity of the Bevington and Sons premises on the evening of the murder, testimony that the prosecution offered as placing the defendant at the scene of the crime at the relevant hour. The prosecution opened its case by setting out the circumstances of Sarah Millson's death as established at the inquest, the severity of her injuries, the probable use of the missing crowbar as the murder weapon, and the timing of the attack as indicated by the state of her wounds when discovered by Elizabeth Lowes. Having established these facts, the prosecution proceeded to draw the connection between the victim and the defendant, presenting evidence of Smith's history of extorting money from her and suggesting that this history supplied a plausible reason for him to have wished her dead, whether to silence her to escape a demand she may have made of him, or for some other cause connected to their financial dealings. The witness identification formed the centerpiece of the prosecution's effort to place Smith at the scene. The witness testified that she had observed a man leaving the area of the premises on the evening in question, and that she had subsequently identified that man as William Smith. The prosecution presented this testimony as direct evidence connecting the defendant to the location of the crime at the time it was committed, evidence that, combined with the established motive, was intended to satisfy the jury of his guilt. The defence mounted against this case proved formidable. Smith's legal representatives, whose names have not survived in the sources reviewed, presented what the fuller account of the case describes as a rock-solid alibi, evidence intended to establish that Smith could not have been present at the Cannon Street premises at the hour the attack was believed to have occurred. The precise nature of this alibi evidence, whether it rested upon the testimony of named witnesses who placed Smith elsewhere, or upon some other form of proof, is not detailed in the sources examined, though its effect upon the proceedings is recorded as having been considerable. Alongside the alibi evidence, the defence turned its attention to the central weakness in the prosecution's case, the witness identification of Smith as the man seen leaving the premises. Defence counsel established, in the course of cross-examination or through evidence separately introduced, that the witness who had made this identification had received assistance from police officers in doing so. This revelation struck directly at the reliability of the identification, raising the possibility that the witness had been guided, whether deliberately or inadvertently, toward identifying Smith rather than arriving at that identification independently. The exposure of this circumstance is recorded both in contemporary commentary and in later historical treatment of the case as having severely undermined the prosecution's case before the jury. The trial proceeded through the presentation of this evidence and its testing under cross-examination, with the defence pressing its case that the identification evidence could not be relied upon and that the alibi evidence placed Smith elsewhere at the material time. The prosecution, for its part, continued to press the significance of Smith's established history of financial pressure upon Sarah Millson as evidence of motive, though motive alone, absent reliable evidence placing the defendant at the scene, was recognised even at the time as an insufficient foundation upon which to found a conviction for murder. Following the conclusion of the evidence and the closing addresses of counsel on both sides, the presiding judge summed up the case for the jury, a stage of the proceedings whose specific content has not survived in the sources examined. The jury then retired to consider its verdict, weighing the strength of the alibi evidence and the compromised identification against the motive the prosecution had sought to establish. the jury returned a verdict of not guilty. William Smith was acquitted of the charge of murdering Sarah Millson, and he was discharged from the dock a free man. The verdict reflected the jury's assessment that the prosecution had failed to establish his guilt to the standard required in a criminal trial, an assessment substantially shaped by the alibi evidence presented on his behalf, and by the exposure of the flawed process by which the principal identifying witness had arrived at her identification of him. The acquittal of William Smith brought the criminal prosecution arising from Sarah Millson's death to a close, without any person having been convicted of her murder. No further suspect was brought before the courts in connection with the case, and the surviving record does not indicate that the City of London Police pursued any renewed line of inquiry following the conclusion of the trial. The case, having proceeded through investigation, inquest, and a full criminal trial, ended with the question of who was responsible for Sarah Millson's death formally unanswered. Contemporary and later commentary upon the case has been consistently critical of the conduct of the investigation, and in particular of the manner in which the identification evidence against William Smith was obtained. The historian Jan Bonderson, in his account of the case, treats the assistance given by police officers to the identifying witness as a clear instance of flawed investigative practice, one that not only failed to secure a conviction against Smith, but that may also have foreclosed the possibility of identifying the true perpetrator if Smith himself was not responsible for Sarah Millson's death. The consumption of investigative and prosecutorial resources upon a case that ultimately collapsed at trial left little apparent avenue for the investigation to be reopened or redirected toward other possibilities once the trial had concluded. The immediate aftermath of the acquittal left the household of Messrs Bevington and Sons and the wider community along Cannon Street without a resolution to the violent death that had occurred within its walls. Sarah Millson's death remained, from the conclusion of the trial onward, an unsolved case within the records of the City of London Police. Its file retained, but its central question never answered. William Smith's subsequent life, following his discharge from the Old Bailey, is not documented in the sources examined for this case, and no further connection between him and the investigation into Sarah Millson's death is recorded. The case of Sarah Millson has survived into the present day, chiefly within the specialist literature devoted to unsolved Victorian murders of women, rather than within wider popular memory. It appears in Jan Bonderson's Rivals of the Ripper, a study devoted specifically to unsolved murders of women in late Victorian London, a work that situates cases such as this one within the broader context of violent crimes against women that preceded and were later overshadowed by the murders attributed to Jack the Ripper in the autumn of 1888. The case is also recorded within the catalogue of the National Archives, under a file reference maintaining the official documentation generated by the original police investigation and subsequent inquest and trial. Retrospective press and podcast treatments of forgotten Victorian London murders have, on occasion, revisited the case as one example among several of women whose violent deaths in this period were never satisfactorily resolved. No novel, ballad, stage play, or film adaptation of the case has been identified among the sources examined, and no legal precedent or point of enduring significance to English criminal law is attributed to the trial of William Smith. No physical memorial to Sarah Millson is recorded as having been erected. The historical significance of the case of Sarah Millson rests less upon its impact at the time, which appears to have been limited to City of London press coverage and the ordinary processes of investigation and trial, than upon its later treatment as representative of a category of case, the unsolved murder of a Victorian woman, that has drawn renewed attention from historians and writers examining the period before the Ripper murders brought such crimes to sustained national and international notice. The case illustrates, within the specific context of the City of London in 1866, both the vulnerabilities faced by women whose marital circumstances place them at risk of financial exploitation, and the investigative shortcomings that could, even when an arrest and trial followed swiftly upon a killing, leave a case permanently unresolved. The City of London Police, a smaller force operating within its own jurisdiction, distinct from the metropolitan force covering the districts beyond the city's boundary, has been identified in retrospective accounts as having handled the identification evidence, in this case in a manner that fell short of the standard required to secure a safe conviction, a criticism that has attached specifically to the conduct of this investigation rather than to the broader policing of the city in this period. The social context surrounding Sarah Millson's death reflects several features characteristic of mid-Victorian London. The practice of retaining live-in domestic staff within commercial premises, common among city trading firms of the period, placed women such as Sarah Millson and Elizabeth Lowes in positions of considerable responsibility, resident within buildings that held goods of substantial value and expected to maintain order and security during the hours when the firm's principals were absent. The law governing marriage in this period offered little protection to a woman whose husband had deserted her, leaving her without the means to dissolve a marriage that divorce law of the time made difficult and costly to end, and exposing her, should she remarry in the belief or hope that her situation permitted it, to the criminal offence of bigamy and to the personal vulnerability that offence entailed should it become known to others. It was this vulnerability, according to the fullest surviving account of the case, that William Smith is understood to have exploited in the period leading up to Sarah Millson's death, a circumstance that the investigation identified as a plausible motive, but that a jury presented with a compromised identification and a strong alibi ultimately declined to treat as sufficient grounds for conviction. The mystery of the unidentified woman observed sheltering upon the doorstep of the Bevington and Sons premises on the evening of the 11th of April has remained, in every subsequent account of the case, one of its most enduring and unresolved features. She was seen only briefly, framed against the heavy rain that fell that evening, and she declined the offer extended to her to step inside out of the weather, replying only that she could not come in before moving away into the wet street. No name was ever attached to her. No later witness came forward to claim acquaintance with her, and no subsequent inquiry succeeded in tracing her movements before or after the moment she was observed. She does not appear again in any surviving records connected with the case, and the investigation, so far as the sources reviewed indicate, was unable to establish whether her presence on the doorstep bore any relation whatsoever to the attack that took place within the building later that evening, or whether she was, as seems equally possible, an entirely unconnected passerby seeking momentary shelter from a storm on an ordinary city street. The detail survives in the case file precisely because it was never resolved, a fragment of the evening's record that neither confirms nor excludes any theory of the crime, and that has continued to draw the attention of those who have examined the case in the years since. The premises of Messrs Bevington and Sons themselves offer a further point of context for understanding the setting in which Sarah Millson lived and died. Leather-selling firms of this type occupied a significant place within the commercial life of the City of London in the mid-19th century, receiving raw and finished hides from tanneries across Britain and from overseas markets, storing them within warehouse premises before onward sale to the trade. The interior of such a warehouse in 1866 would have consisted of storage areas given over to packing cases and stacked goods, offices and counting rooms where the business of the firm was transacted, and within the same building or an adjoining structure, the domestic quarters occupied by staff such as Sarah Millson and Elizabeth Lowes. The tools of the trade, among them the small crowbars used to open packing cases upon their arrival or before their dispatch, were kept readily to hand within such premises, a detail that placed a ready implement within reach of anyone present in the building on the night of the murder. Whether that person had entered from outside or was already known to the household, Elizabeth Lowe's, whose discovery of Sarah Millson at the foot of the staircase brought the household's ordinary evening to its violent end, is recorded in the sources examined only in connection with this single act of discovery. No further account survives of her own background, her subsequent testimony beyond what was recorded at the inquest and at trial, or her life following the conclusion of the case. She remains, within the surviving record, a figure defined entirely by the moment in which she descended the stairs and found her fellow servant grievously injured, a moment that placed her at the centre of the investigation's earliest hours without leaving any further trace of her own experience of the case in the sources available. The offence of bigamy, which lies at the centre of the motive theory advanced by investigators against William Smith, carried real legal and social consequences for a woman in Sarah Millson's position during this period. English law in the mid-19th century made no straightforward provision for a deserted wife to dissolve her marriage and remarry with legal security. Divorce, made possible under civil law only from 1857 onward, remained a costly and difficult process, largely unavailable to women of modest means, and a wife whose husband had simply disappeared, without formal legal proceedings to establish the end of the marriage, remained bound to him in the eyes of the law, regardless of how many years might pass without word of him. A woman in such a position who entered into a second marriage, whether from a genuine belief that her first husband was dead, from desperation or from some other cause, exposed herself to prosecution for bigamy, should the matter come to the attention of the authorities, and exposed herself in the meantime to exploitation by anyone who learned of her situation and chose to use that knowledge against her. It is this precise vulnerability that the fuller account of Sarah Millson's case identifies as the likely source of William Smith's hold over her, though, as recorded elsewhere in this account, an alternative explanation involving an unpaid debt also appears among the sources reviewed, and the true nature of the pressure between them was never conclusively established, either at the inquest or at trial. Cases of this general character, women whose deaths within London went uninvestigated to a satisfactory conclusion, or whose killers were never brought to justice, were not unique to Sarah Millson's experience in the years surrounding her death. Jan Bonderson's study of unsolved murders of women in late Victorian London situates her case alongside a number of others from the same general period, cases in which the ordinary processes of investigation, inquest, and in some instances, trial, failed to produce a conviction, leaving the victims' deaths formally unresolved within the historical record. These cases, taken together, form part of the broader background against which the murders later attributed to Jack the Ripper in 1888 would come to be understood by historians as an escalation in public attention, if not in underlying frequency, of a pattern of violence against women in London that had already been documented, if imperfectly resolved, in the decades preceding. Sarah Millson's case, occurring more than 2 decades before those later killings, stands as one such earlier instance, notable for the swiftness with which a suspect was identified and brought to trial, and equally notable for the manner in which that prosecution collapsed under the weight of its own evidential weaknesses. The file generated by the investigation into Sarah Millson's death, together with the record of William Smith's trial at the Old Bailey, has been preserved within the National Archives, catalogued under a reference maintaining the documentation associated with the case. This survival has allowed later historians and researchers to reconstruct the essential outline of the case, even in the absence of a complete contemporary press record or a full transcript of the trial proceedings themselves. The preservation of such records, routine as it was under the administrative practices of the period, has proven significant in allowing a case that received only modest attention at the time to be examined in some detail more than a century and a half later, its central facts recoverable, even where its central question, the identity of the person or persons responsible for Sarah Millson's death, remains as unanswered today as it was when the jury at the Old Bailey returned its verdict in 1866. The trial of William Smith, occurring as it did at the Old Bailey in the year 1866, followed the standard procedures of the Central Criminal Court as they had developed by the middle of the 19th century. Juries in cases of this nature were composed of 12 men, drawn from among the propertied classes eligible for jury service, under the qualifications then in force, and were tasked with weighing the evidence presented by prosecution and defence counsel under the direction of the presiding judge. A capital charge such as murder demanded of the jury a decision reached beyond reasonable doubt, a standard the prosecution in Smith's case ultimately failed to satisfy once the alibi evidence and the compromised identification had been placed before the court. The proceedings would have unfolded across a single sitting day, or, depending on the volume of evidence presented, across a short span of days, in keeping with the general practice of the period for cases that did not involve an unusually extensive body of evidence or an unusually large number of witnesses. Press coverage of the case at the time of Sarah Millson's death and of William Smith's subsequent trial appears, from the sources examined, to have been limited in scope and confined largely to the ordinary reporting the London papers extended to city crimes of this nature, rather than to the sustained and extensive coverage that would later attend more widely publicised murders of the Victorian period. No sources examined for this case indicate that it achieved the degree of public notoriety attached to the era's most famous crimes, and its subsequent acquittal, rather than a conviction and execution, may have contributed to its relatively swift departure from public attention once the Old Bailey proceedings had concluded. A case that ended in a hanging carried an obvious and dramatic conclusion for the press of the period to report. A case that ended in acquittal, with the underlying question of guilt left formally unresolved, offered less of a narrative conclusion for contemporary newspapers to dwell upon, and the case appears to have receded from public notice accordingly. Its full details preserved chiefly within the official record rather than within the sustained attention of the popular press. It is this quality, a case fully documented within the official record, yet largely absent from the popular memory of Victorian crime, that has made Sarah Millson's death of particular interest to later historians examining the category of unsolved murders of women in the decades before the Ripper killings brought such crimes to wider and more sustained public attention. The case demonstrates that the machinery of Victorian criminal justice, investigation, inquest, committal, and trial could be set in motion swiftly and could proceed through each of its stages without irregularity, and could nonetheless conclude without resolving the central question of who had taken a woman's life. The verdict returned at the Old Bailey in 1866 closed the criminal proceedings arising from Sarah Millson's death. It did not close the question the proceedings had been convened to answer. The case of Sarah Millson also appears among broader compiled lists of unsolved murders committed within the United Kingdom during the Victorian period, catalogues that draw together cases such as hers precisely because they share the common feature of a criminal investigation that reached trial, or in some instances did not, without ever producing a conviction that satisfied the courts or the historical record. Her inclusion within such lists rests upon the same body of evidence examined throughout this account: the National Archives file documenting the original investigation, the record of William Smith's trial and acquittal at the Old Bailey, and the narrative treatment given to the case within Bonderson's study of unsolved murders of women in the period. The Old Bailey's own surviving proceedings, maintained and made available for later research, offer a further avenue through which the mechanics of Smith's trial, its precise date, its presiding judge, and the counsel engaged on either side might in principle be more fully established, though such details remain, within the sources consulted for this account, undetermined. What the surviving record leaves beyond dispute is the outline of the case itself. A woman employed in a position of trust within a City of London trading firm was struck down within the household she served. On an April evening, marked by heavy rain and by the passing presence of a stranger never identified. A weapon was removed from the scene by whoever had used it. A man with a history of extracting money from her was arrested, tried and acquitted, his defence exposing a flaw in the identification evidence brought against him that has drawn criticism from those who have examined the case in the years since. No other person was ever charged. The file was closed, its questions left standing exactly where the jury at the Old Bailey had left them in 1866. Unresolved then and unresolved now. The preservation of case files such as the one generated by the investigation into Sarah Millson's death reflects the general record-keeping practices adopted by the City of London Police and by the Old Bailey during the mid-19th century. Investigations of this period generated a body of documentation, witness statements, reports compiled by investigating officers, and the formal record of committal proceedings before a magistrate, all of which were retained as a matter of administrative routine rather than because any particular case was expected to attract lasting attention. Trial proceedings at the Old Bailey were likewise documented and retained, forming part of the broader body of records maintained by the court across the whole of the 19th century. It is this routine administrative retention, rather than any contemporary judgment that Sarah Millson's case was of special significance, that accounts for the survival of sufficient documentation to permit a reconstruction of the case more than a century and a half after the events themselves. The City of London Police, established as a force distinct from the Metropolitan Police that governed the surrounding districts of the capital, held responsibility for criminal investigation within the square mile throughout this period, including the stretch of Cannon Street on which Sarah Millson lived and died. The force's jurisdiction, though limited in geographic extent compared with that of the Metropolitan Force, encompassed a district of considerable commercial importance and correspondingly high value in the goods and money that passed through it daily, a circumstance that shaped the nature of much of the crime the force was called upon to investigate, from theft and fraud connected with the city's trading houses to, on occasion, offences of violence such as the one that ended Sarah Millson's life. The handling of her case by this force and the criticism later directed at its conduct of the identification evidence against William Smith forms part of the broader historical record concerning the investigative practices of a force still developing the procedures that would, in later decades, come to characterise detective work within British policing more generally. Sarah Millson's death, considered within this administrative and institutional context, stands as one case among the many the City of London Police investigated during this period, distinguished from most others chiefly by its outcome, an arrest and a trial that failed to produce a conviction, and by its subsequent preservation within archival and historical treatments of unsolved Victorian crime. The file remains within the National Archives exactly as it was closed in 1866, its contents available to any researcher who wishes to examine the original documentation generated by the investigation, the inquest, and the trial that together constitute the full surviving record of her death. The case of Sarah Millson was entered into the historical record. No further legal proceedings followed, the record closed without resolution. That is where the record of the first case ends. We turn now to a second account, quieter than the one just closed and set some years apart from it, in a different corner of London, where a family made its living behind a shop counter, and where the same unanswered question sits at the end of the file as it did at the start. The case of Sarah Squire and her daughter Christiana Squire begins in Hoxton, in the Shoreditch district of Middlesex, in the summer of 1872. Hoxton, at that time, was a densely built quarter of London's East End, given over largely to small trade, workshops, and modest retail premises fronting narrow residential streets. The parish had grown rapidly over the preceding decades as London's population expanded eastward, and by the early 1870s it housed a mixture of artisans, shopkeepers, and labouring families living in close proximity to one another, many of them known to their neighbours, by name and occupation. Hyde Road itself was a street of this character, lined with terraced houses whose ground floors served as shop fronts, their upper stories given over to living quarters for the families who kept them. Number 46. Hyde Road was one such property. It housed a wholesale picture and print dealing business, a modest concern trading in engravings, prints, and framed images, the kind of enterprise that served both individual customers and other tradesmen who purchased stock for resale. The business was operated in the summer of 1872 by Sarah Squire, a widow. Her exact age at the time of her death is not established with certainty in the surviving record, with one detailed account giving her age as 73 and another placing it at 76. The lower figure is preferred here, though the discrepancy between sources should be understood as unresolved. What is documented is that she was a woman of advanced age who had continued to operate a trading business from her own premises, a position that placed her among the more independent tradeswomen of her district. Sarah Squire was not alone in the shop. She lived and worked there with her daughter, Christiana Squire, who remained unmarried and resided with her mother at the Hyde Road address. Christiana's age at the time of the murders is likewise contested between sources, with one account placing her at approximately 30 years of age and another at 36. The lower figure is preferred in this account, consistent with the more detailed of the two surviving sources, though the conflict between the figures is noted for the record. Christiana appears to have assisted her mother in the running of the shop, and the two women's daily lives were bound closely together by both family and trade. No documented record survives of either woman's birthplace, parentage, or early life prior to the period immediately surrounding the murders. Sarah Squire's husband is not named in the sources reviewed, nor is the date of his death or his occupation recorded. What can be established is that Sarah had been widowed by 1872 and had, by that date, established or continued the wholesale picture and print business under her own management, a fact that speaks to her standing as a woman of some independent means within her community, however modest. The Squire family extended beyond the two women who lived at Hyde Road. Sarah had at least 3 other adult children whose names appear in connection with the case. Jemima Squire, the eldest daughter, did not reside at the Hyde Road premises, but lived elsewhere, apparently established in her own household. Frank Squire, a son, had a documented history of confinement at Colney Hatch Lunatic Asylum, a large county institution in Middlesex, and was, at the time of the murders, employed at the infirmary attached to Shoreditch Workhouse. Edward Squire, another son, worked as a musician and was, at the time the murders occurred, absent from London on a professional engagement in Brentwood. A grandson, George Squire, aged 17, also appears in the record, indicating that the family maintained connections across more than one household in the district. Christiana Squire, for her part, was reported to be receiving the attentions of a suitor, George Niblett, a stonemason by trade, described in the record as a man who was courting her at the time of her death. The picture and print trade in which Sarah Squire was engaged was a common one in Victorian London, sustained by demand for engravings, illustrations, and framed prints among a public increasingly accustomed to decorating their homes with affordable reproductions of paintings and popular scenes. A wholesale dealer in this line of goods would have supplied stock to smaller retailers as well as selling directly from the shop counter, and the business would have required the proprietor to maintain relationships with printers, framers, and other tradesmen across the district and beyond. That Sarah Squire, a widow well advanced in years, continued to manage such a business with the assistance of her daughter suggests a household that depended on its own labour and management rather than on inherited wealth or a pension from her late husband's estate, though no specific financial details of the business survive in the record reviewed. In the days immediately preceding the murders, the Hyde Road premises had reportedly been the target of an attempted burglary. This detail is documented in a secondary account of the case and is noted here as a precursor event of possible significance, though no source establishes a proven connection between the attempted break-in and the murders that followed. The two events occurred in close proximity, and the coincidence was noted by those investigating the case at the time, but the historical record does not permit a firm conclusion that the earlier attempt and the later crime were the work of the same hand or were connected in any other way. It is presented here as a documented fact standing near the case, not as an established cause of it. On the morning of Wednesday, the 10th of July, 1872, Sarah and Christiana Squire were engaged in the ordinary business of the shop. Multiple witnesses later testified to having seen one or both women going about their usual activities between approximately 9 and 11 o'clock that morning. Nothing in the surviving testimony suggests that either woman behaved in a manner that departed from her habitual routine, and no witness reported any unusual visitor, disturbance, or exchange during these hours. The morning, as far as the record permits reconstruction, proceeded as an ordinary Wednesday would have proceeded in a small shop on a working street in Hoxton. A degree of uncertainty attaches to the precise hour at which the two women were last seen alive. A neighbour, Caroline Richards, later gave an account placing Sarah Squire at the door of the shop as late as 12:30 and reported hearing cries of murder at around that hour. This account stands in tension with other physical evidence recovered from the scene, namely a clock within the shop that had stopped at 12 o'clock precisely, its outer case removed. The stopped clock has been taken by those who have examined the case as the more reliable indicator of the time of the attack, though the discrepancy between the clock and Caroline Richards' testimony was never resolved during the investigation and remains an open question in the record. Whether the clock was disturbed during the violence itself or during the ransacking of the premises that followed is likewise not established with certainty. What can be said of the periods immediately preceding the crime is that it was, by all surviving accounts, unremarkable. Two women, a mother and a daughter, opened their shop as on any other working day, attended to customers and to the business of the trade, and gave no indication to those who observed them of any anticipation of danger. The attempted burglary of the preceding days stood as the only documented irregularity in an otherwise ordinary pattern of days, and even that irregularity was not, at the time, understood by the family or their neighbours as a warning of what was to come. No individual was ever formally charged with the murders of Sarah and Christiana Squire, and the perpetrator's identity was never established. The investigation that followed the discovery of the bodies turned, in its early stages, toward members of the family itself, a direction consistent with standard investigative practice of the period when a household has been violently attacked, and the premises show signs of ransacking that might equally have been staged to disguise an inside hand. 3 individuals connected to the family were investigated in this connection and were, in each case, cleared through documented alibi. Frank Squire, the son with a history of confinement at Colney Hatch Lunatic Asylum, attracted particular early suspicion, a fact that owed a great deal to prevailing attitudes toward those who had at some point been institutionalized for reasons of mental health. A prior period of confinement was, in the investigative thinking of the period, often treated as grounds for suspicion in the absence of any other evidence, and Frank Squire's history made him an early and perhaps inevitable focus of police attention. He was, however, documented as having been at his place of employment at Shoreditch Workhouse Infirmary at the time the murders were believed to have occurred, and this employment record provided him with an alibi that removed him from further suspicion. Edward Squire, the second son, was likewise investigated and cleared. He was documented as having been engaged in professional work as a musician in Brentwood at the time of the murders, at a sufficient distance from Hoxton to preclude his presence at the scene. His absence from London on the day in question was corroborated to the satisfaction of investigators, and he too was eliminated from the inquiry. George Niblett, the stonemason who had been courting Christiana Squire, was the third individual investigated in connection with the case. His trade required him to work at locations across the district, and on the day of the murders, he was documented as having been employed near Kingsland Road Bridge, a location that provided him with a corroborated alibi. Having been so accounted for, he too was cleared of suspicion, and the investigation, having eliminated the three individuals most closely connected to the family and to Christiana Squire in particular, was left without a named suspect. The elimination of these three men left the investigating officers with no clear direction in which to proceed, and no further named suspect emerges from the surviving record of the original 1872 investigation. The case would, however, produce one further documented development many years later, in the form of a confession that proved to be false. In August of 1888, a chairmaker named Thomas Wright, then 36 years of age, appeared before Worship Street Police Court and confessed to having committed the murders of Sarah and Christiana Squire using a crowbar. Wright's confession was investigated by the authorities, who established that he had, in fact, been at his place of employment at the time of the murders and could not have been present at Hyde Road on the day in question. Wright attributed his false confession to intoxication at the time he made it. The presiding magistrate, Mr. Saunders, discharged him once the falsity of the confession had been established, and is recorded as having expressed frustration at the limitations of the law in punishing those who made confessions of this kind. The episode is documented here as a proven false confession, investigated and dismissed by the authorities, rather than as evidence bearing on the identity of the true perpetrator, whose name was never established. The crime itself occurred at 46 Hyde Road on the afternoon of the 10th of July, 1872, at or around the hour indicated by the stopped clock found within the shop. The premises, when subsequently examined, showed clear signs of having been ransacked. Drawers had been forced open and their contents scattered about the floor, and doors and windows were found unfastened, a state of disorder consistent with a search for money or valuables conducted either before or after the violence took place. Both women had been struck about the head with a heavy object, most likely a hammer or an iron bar, though the weapon itself was never recovered and its precise nature was never conclusively established. Sarah Squire's injuries were reported to have been the more severe of the two. Among the disordered contents of the shop, a will belonging to the family was discovered tucked beneath a sofa, contained within a paper bag, a detail whose significance was never determined and which the record does not connect to any established motive for the crime. The discovery of the crime was made by a boy named William Eyre, who arrived at the shop on an errand at approximately 1:30 in the afternoon. Eyre noticed marks of blood upon the counter, and recognising the significance of what he had seen, raised the alarm rather than proceeding further into the premises on his own. His prompt action brought the matter to the attention of the police within a short time of his arrival, and the response that followed was correspondingly swift. Police Constable James Kingsley was among the first officers to enter the premises, and it was Kingsley who discovered the body of Sarah Squire, lying behind the shop counter where she had evidently fallen. The body of Christiana Squire was found elsewhere within the premises, positioned partly within the passage connecting the shop to the rear of the building and partly within the back parlour itself, a distribution of her remains that suggested she may have attempted to move from one part of the house to another during or after the attack upon her, whether in an effort to escape her assailant or to reach her mother. The condition of the shop, taken together with the position of the two bodies, presented investigating officers with a scene that spoke plainly to violence, but left a great deal open to question regarding its sequence and its cause. The disorder among the drawers and papers indicated that whoever had entered the premises had conducted a search of some kind, whether before, during, or after the attack upon the two women, could not be determined with certainty from the physical evidence alone. The unfastened state of the doors and windows offered no clear indication of the point of entry or exit used by the assailant, and no article of clothing, tool, or other physical evidence was recovered at the scene that could be connected with confidence to a particular individual. The investigation into the murders of Sarah and Christiana Squire was formally opened in the hours following the discovery of the bodies, falling under the jurisdiction of the Metropolitan Police, within whose area Hoxton then lay. Inspectors Ramsey and Palmer are named in the surviving record as the officers principally responsible for directing the inquiry. Officers were dispatched to canvass the immediate neighbourhood, and statements were taken from residents and tradespeople in the vicinity of Hyde Road in the days that followed the murders, in an effort to establish the movements of the two women during the morning and early afternoon of the 10th of July, and to identify any person seen entering or leaving the premises during that period. Among those who provided statements to investigators was Caroline Richards, whose account of hearing cries of murder at around 12:30 has already been noted, and whose testimony placed her in the position of a critical, if not entirely reconciled, witness to the timing of the attack. Henry Einel, a butcher trading in the vicinity, was another individual who gave testimony in connection with the case, as was Charles Wallen, a carman residing at number 44 Hyde Road, whose proximity to the Squire premises made his observations of particular interest to the investigating officers. George Squire, the 17-year-old grandson of Sarah Squire, also gave testimony, his family connection to the victims placing him in a position to speak to matters that other witnesses could not address. Other witnesses whose statements form part of the surviving record include James Jones, a youth of 17, who reported having collided with an unidentified man on the day of the murders, an account that investigators appear to have pursued without it yielding a named suspect. Charles Henry Hassler, described in the record as a window mender and greengrocer, and Walter Chapman, a carpenter, likewise provided statements, their trades placing them among the working population of the immediate district, and their testimony forming part of the broader effort to reconstruct the movements of persons in and around Hyde Road on the day in question. The investigation proceeded over the following weeks without producing a named suspect against whom sufficient evidence could be brought. The elimination of Frank Squire, Edward Squire, and George Niblett through documented alibi has already been described, and their removal from the inquiry left investigators without a clear line of pursuit. In an effort to generate further information, a reward was offered by the authorities for information leading to the identification and conviction of the person or persons responsible for the murders. This reward was subsequently increased to £200, a substantial sum for the period, reflecting the seriousness with which the case was regarded by the authorities and the pressure that a double murder of this nature placed upon the investigating force to produce a result. Despite the size of the reward and the sustained efforts of the investigating officers, no information was received that led to the identification of a viable suspect, and the case remained at the conclusion of the formal investigation without resolution. The medical examination of Sarah and Christiana Squire was conducted by Dr. Hawthorne, who determined that both women had died as a result of heavy blows to the head. Dr. Hawthorne's examination indicated that the injuries were consistent with a weapon, such as a hammer or an iron bar, though, as has been noted, no such weapon was ever recovered in connection with the case. His findings established that Sarah Squire's injuries were the more severe of the two, a determination that was entered into the record without further elaboration as to the precise nature or extent of the wounds themselves. The medical evidence, taken as a whole, established the cause of death for both women with reasonable confidence while leaving open certain questions, chiefly regarding the exact hour at which the attack occurred, a matter on which the medical findings could offer only an approximate range consistent with the physical evidence of the stopped clock and the surrounding witness testimony. The coroner's inquest into the deaths of Sarah and Christiana Squire was convened before Mr. Humphreys, the coroner, assisted by Mr. Richards, the deputy coroner. The inquest proceeded over 3 separate sessions, held on the 21st of July, the 30th of July, and the 2nd of August, 1872, a span of proceedings that reflects the complexity of the case and the number of witnesses called to give testimony before the jury. Among those who appeared were Caroline Richards, Henry Inall, George Squire, Charles Wallen, James Jones, Charles Henry Hasler, and Walter Chapman, each contributing their portion of the account to the jury's understanding of the events surrounding the deaths. It was during the course of these inquest proceedings on the 21st of July that a further tragedy befell the Squire family. Jemima Squire, the eldest daughter of Sarah Squire and sister to Christiana, died by her own hand on that date, having cut her throat with a razor at Bow. She was conveyed to Poplar Infirmary, where she died from the effects of blood loss and exhaustion. The surviving record attributes her death to grief and distress in the aftermath of the murders of her mother and sister, though the documentary basis for this attribution is limited to contemporary press characterization rather than any more formal record of her state of mind. Her death is entered here as a documented fact of the case's aftermath, occurring in close proximity to the ongoing inquest proceedings into the deaths of her mother and sister, and standing as a further loss suffered by a family already reduced by violence. At the conclusion of the inquest's 3rd session, the jury returned a verdict of willful murder against some person or persons unknown, a formal finding that left the case open in the absence of any named suspect against whom the evidence could be brought. No trial followed, as no individual was ever charged with sufficient evidence to proceed to a prosecution for the murders of Sarah and Christiana Squire. The investigation, notwithstanding the size of the reward offered and the sustained efforts of the officers assigned to it, concluded without an arrest, and the case entered the historical record as one of the unsolved murders of Victorian London. The false confession offered by Thomas Wright at Worship Street Police Court in August of 1888 stands as the most significant later development in the documentary history of the case, and it deserves to be understood within the context of the case's continued presence in public memory over the 16 years separating the murders from that episode. That a man should come forward, whether through intoxication, disturbance of mind, or some other motive not recorded, to falsely confess to a crime committed so long before, testifies to the degree to which the murders of Sarah and Christiana Squire had remained a point of reference in the public consciousness of the district and to some extent of the city more broadly. The proceedings before Mr. Saunders established without ambiguity that Wright could not have committed the murders, his place of employment on the day in question being a matter of documented record, and the magistrate's discharge of him closed that particular episode without further legal consequence. Wright's own explanation, that intoxication had led him to make a confession he could not substantiate, was accepted by the court, and the matter concluded there. It is recorded that Mr. Saunders expressed frustration at the absence of any legal mechanism by which such a false confession could itself be punished, a detail that speaks to the practical difficulties faced by the courts of the period in managing cases where public notoriety invited exactly this kind of spurious admission. The case of Sarah and Christiana Squire has persisted in the years since, chiefly within specialist archives devoted to the history of Victorian crime. It is documented on record-keeping sites concerned with the history of London crime, and it appears in dedicated accounts of the case drawing upon contemporary press coverage of the murders and the subsequent inquest. Contemporary newspapers of 1872 are recorded as having applied the phrase "the Hoxton horror" to the case, a piece of period phrasing that reflects the impact the double murder had upon public opinion at the time, situated as it was within a district that, while no stranger to petty crime, had not previously been marked by a killing of this severity and mystery. The case is further referenced in broader compilations of unsolved murders from the United Kingdom prior to the 20th century, where it is listed alongside other cases from the period that similarly concluded without a named perpetrator. No novel, ballad, stage production, or film is documented as having been produced in connection with the case, and no memorial to either Sarah or Christiana Squire is recorded as having been erected. The case's afterlife, in other words, has been confined almost entirely to the documentary and archival record rather than to any wider work of cultural adaptation, a circumstance consistent with its classification as a case known chiefly to those with a specific interest in the history of Victorian crime rather than to a general audience. The historical legacy of the case rests in large part upon the completeness of its documentary record, notwithstanding its lack of resolution. The surviving account preserves the names of the investigating officers, the coroner and deputy coroner who presided over the inquest, and a substantial number of the witnesses called to give testimony, a level of documentary detail that allows the case to be reconstructed with considerable precision even in the absence of a solved outcome. It is this completeness of record, set against the case's continuing lack of resolution, that has sustained its place within specialist true crime archives over more than a century, offering researchers and historians of the period a fully documented example of a Victorian investigation that pursued every available line of inquiry and yet failed to identify a perpetrator. No change to law or police procedure is recorded as having resulted from the case, and its significance rests instead upon its value as a documented instance of the investigative methods and limitations of the period. The social and historical context surrounding the murders reflects the character of Hoxton and of the wider East End of London during the early 1870s. The district was, by this period, densely settled and given over substantially to small trade and manufacture, its population drawn from the ranks of artisans, shopkeepers and labourers, who together sustained a local economy built upon countless modest enterprises of the kind Sarah Squire had operated from her premises on Hyde Road. A wholesale picture and print dealing business of this description would have depended upon steady custom among both individual buyers and other tradesmen purchasing stock for resale, and its operation by a widow of advanced years, assisted by her unmarried daughter, situates the Squire household among the more independent, if modest, commercial concerns of the district. The presence of Frank Squire's history of confinement at Colney Hatch Lunatic Asylum within the family's documented circumstances reflects, in turn, the prevailing attitudes of the period toward mental illness and institutionalization, attitudes that made a prior period of confinement grounds for suspicion in the eyes of investigators confronted with a violent crime, and no immediate alternative explanation. That such a history should attach itself so readily to a family member in the absence of any other evidence against him illustrates a pattern common to police investigations of the era, in which those who had at some point been institutionalized bore a particular burden of suspicion regardless of their documented movements or conduct. The scale of the reward offered in connection with the case, ultimately raised to £200, further situates the murders within the broader pattern of public and official concern that attended notorious unsolved crimes of the Victorian period. Rewards of this magnitude were not offered lightly, and their scale reflects both the severity of the crime and the pressure placed upon the authorities to produce a result commensurate with the public alarm that a double murder of this nature was liable to provoke within a settled residential and commercial district. That so substantial a reward failed to produce a viable suspect stands as a measure of the difficulty the case presented to investigators working without the forensic methods that would, in later decades, become available to detectives confronted with comparable crimes. The physical setting of the crime itself, preserved through the testimony gathered at the inquest and through contemporary press description, offers a picture of an ordinary East End shopfront transformed, within the space of an afternoon, into the scene of a double killing. The shop at 46 Hyde Road would have presented, on any other day, the familiar arrangement of a small trading premises of its kind. A counter separating the proprietor from her customers, drawers and shelving holding the stock of prints and engravings that formed the substance of the family's trade, and, behind and above the shop itself, the domestic rooms in which Sarah and Christiana Squire conducted their private lives. The stopped clock, its case removed, and its hands fixed at 12, stands as the most enduring physical detail to survive from the scene. A small mechanical witness to the hour of the attack that neither corroborating testimony nor subsequent investigation was ever able to fully reconcile with the account offered by Caroline Richards. The will discovered tucked beneath the sofa in its paper bag occupies a similarly ambiguous position within the record. A domestic object, displaced amid the violence and the search that accompanied or followed it, its presence in that location never explained and never connected by the investigating officers to any specific motive for the crime. The rhythms of a working Wednesday on Hyde Road, interrupted by the events of the 10th of July, would ordinarily have included the passage of errand boys, such as William Eyre between the shops and households of the street, the movement of tradesmen like Henry Innell and Charles Wallen about their daily business, and the general commerce of a district whose residents were, for the most part, known to one another by name and occupation. It was within this setting, ordinary in every particular, until the discovery made by Eyre shortly after 1:30 that afternoon, that the deaths of Sarah and Christiana Squire were brought to public and official attention, and it was against this same backdrop of small trade, close-set housing, and mutual acquaintance among neighbours that the investigation which followed was conducted, drawing as it did upon the testimony of butchers, carmen, carpenters, and greengrocers whose ordinary presence upon the street had made them witnesses, however incidental, to the final hours of the two women's lives. The trade in which Sarah Squire had built her livelihood occupied a particular place within the commercial life of Victorian London. Wholesale dealers in prints and pictures supplied a market that had grown steadily across the middle decades of the century, as improvements in reproduction allowed engravings and lithographs of popular scenes, portraits, and religious subjects to be produced cheaply enough for purchase by households of modest means. A dealer operating from premises such as those at Hyde Road would have maintained a stock drawn from various printers and publishers, offering pieces for sale both to individual customers furnishing their own homes and to smaller retailers who purchased in quantity for resale elsewhere in the city. The management of such a business required a working knowledge of suppliers, prices, and the tastes of a varied clientele, and its continued operation under Sarah Squire's direction, years after she had been left a widow, indicates a woman who had assumed and sustained full responsibility for a commercial concern of some complexity. Christiana Squire's role within this business is documented only in general terms, described in the surviving record as one of assistance to her mother in the daily conduct of the shop. The nature of this assistance, whether it extended to bookkeeping, to direct dealing with customers, or to the physical handling of stock, is not specified further. What can be inferred from her presence at the premises and from the consistent description of the two women as living and working together is that Christiana's daily life was organised substantially around the shop and her mother's business, a pattern of life interrupted only by the attentions of George Niblet, the stonemason who is recorded as courting her at the time of her death. Niblet's trade, like that of the carpenters, carmen and butchers, who appear elsewhere in the record of witnesses, situates him among the skilled and semi-skilled working population of the district. A young man whose work in stone would have taken him to building sites and monumental works across a wide area of London, consistent with his documented presence near Kingsland Road Bridge on the day of the murders. The Kingsland Road itself, running north from Shoreditch through Hoxton and beyond, formed one of the principal thoroughfares of the district, connecting the close-built streets around Hyde Road to the wider road network of northeast London. The Regent's Canal, cut through this part of London earlier in the century, ran nearby, its towpaths and wharves forming a further feature of the local landscape and providing employment for those engaged in the movement of goods by water as well as by road. This was a district, in short, defined by movement and trade in equal measure, its streets carrying a constant traffic of tradesmen, carriers and errand boys about their business, a traffic that on any ordinary day would have included figures such as William Eyre, passing between the shops of Hyde Road on whatever commission had sent him there, and which on the 10th of July 1872 brought him, in the ordinary course of that traffic, to the discovery that ended the illusion of an ordinary Wednesday. Frank Squire's connection to Colney Hatch Lunatic Asylum deserves further contextual note, given the weight it carried in directing early suspicion toward him. Colney Hatch, opened some 2 decades before the murders, was among the largest county asylums in England, built to accommodate the pauper insane of Middlesex in numbers that had outgrown the capacity of earlier, smaller institutions. Confinement at such an asylum carried with it, in the public and official mind of the period, an association with disorder and unpredictability that persisted well beyond any individual's discharge or recovery, and it was this lingering association, rather than any specific evidence connecting Frank Squire to the crime, that appears to have directed early investigative attention toward him. His employment at the infirmary attached to Shoreditch Workhouse at the time of the murders places him, notably, on the other side of that same institutional world, working within the medical and welfare apparatus that served the poor of his own district, rather than as a patient within it, a detail that complicates any simple reading of his place within the family's history, but which the surviving record does not develop further. The workhouse infirmary at which Frank Squire was employed formed part of the wider system of poor relief maintained within each London parish and union during this period, providing basic medical care to those unable to afford treatment elsewhere. Employment within such an institution, whether in a medical, nursing, or attendant capacity, was among the more common forms of work available to men in Frank Squire's position, and his presence there at the time of the murders, verified to the satisfaction of the investigating officers, removed him definitively from further suspicion once his alibi had been established. Edward Squire's profession as a musician placed him within a different, though equally documented sphere of London working life. Professional musicians of the period found employment through engagements arranged with theatres, public houses, and private events across the city and its surrounding towns, and an engagement in Brentwood, a market town some distance to the east of London in Essex, would have required Edward Squire's absence from the capital for the duration of the booking. This absence, verified by investigators, provided him with an alibi consistent with the timeline established by the stopped clock and the surrounding witness testimony, and removed him, as it had removed his brother, from the list of individuals into active suspicion. The inquest proceedings, spread across 3 separate sessions between the 21st of July and the 2nd of August, reflect a coroner's process conducted with considerable care, given the complexity of the case and the number of witnesses required to establish as full an account as possible of the circumstances surrounding the 2 deaths. Mr. Humphreys presiding as coroner and Mr. Richards serving as deputy coroner would have overseen the formal taking of testimony from each witness in turn, the jury retiring where necessary to consider the evidence before returning to hear further testimony at each subsequent session. The gap of several days between sessions allowed investigators time to pursue additional lines of inquiry and to bring further witnesses forward, a pattern consistent with inquest practice into cases of unusual complexity during this period, where the coroner's court served not merely to establish a formal cause of death, but to gather and test in open session whatever evidence the ongoing police investigation had managed to develop. The proceedings before Magistrate Mr. Saunders at Worship Street Police Court in August of 1888, arising from Thomas Wright's false confession, took place within a different but related branch of the London judicial system. Police courts of this period served as the first point of formal judicial contact for a wide range of matters, from minor offences disposed of summarily to more serious matters remanded for further proceedings elsewhere. And it was to such a court that Wright's confession was brought for initial examination. The establishment of his alibi through his place of employment allowed the matter to be resolved within a single hearing, without the need for further remand or committal, and Mr. Saunders's recorded frustration at the absence of any means to penalise a false confession of this kind reflects a recurring difficulty faced by magistrates confronted with individuals who, for reasons of intoxication, mental disturbance, or a desire for notoriety, came forward to claim responsibility for crimes they had not committed. The murders of Sarah and Christiana Squire drew substantial coverage in the London press of 1872, coverage that both reflected and amplified the alarm such a crime provoked within a settled residential and commercial district. It was through this press coverage that the case acquired the descriptive phrase, later associated with it, the Hoxton Horror, a form of contemporary shorthand common to the reporting of the period, in which a notorious crime was given a name that fixed it in public memory and distinguished it from the ordinary run of criminal reporting that filled the newspapers of the day. This naming convention served a practical purpose for the press of the period, allowing readers to follow a developing case across successive editions under a consistent heading, and it is through such contemporary press treatment, preserved and later drawn upon by researchers of Victorian crime, that much of the surviving documentary detail of the case has been reconstructed. The offer and subsequent increase of the reward to £200 would itself have been circulated through the press and through formal notices posted within the district, a standard practice by which the authorities sought to encourage members of the public who might possess relevant information, however incidental it might have seemed to them, to come forward. Rewards of this kind were typically funded through a combination of government contribution and, in some cases, subscription from concerned residents or trade associations connected to the victims, though the surviving record of the Squire case does not specify the precise source or division of the £200 offered. That the sum was increased over the course of the investigation, rather than fixed from the outset, suggests that the initial offer failed to produce results sufficient to satisfy the investigating officers or the wider public, and that the increase represented a deliberate escalation intended to widen the pool of potential informants. The aftermath of the murders, already marked by the formal conclusion of the inquest without a named suspect, was compounded by the death of Jemima Squire at Poplar Infirmary on the 21st of July, the same date as the first session of the inquest into her mother and sister's deaths. Poplar Infirmary, serving the poor of the Poplar Union in East London, would have received Jemima Squire in the aftermath of the injury she had inflicted upon herself at Bow, and the surviving record indicates that she succumbed there to the combined effects of blood loss and exhaustion rather than to any immediate cause. Her death, following so closely upon the deaths of her mother and sister, and coinciding with the very proceedings convened to examine those deaths, represents a further and distinct loss suffered by the Squire family within the span of a few short weeks, one attributed by contemporary accounts to the grief and distress occasioned by the murders, though the documentary record does not permit a fuller reconstruction of the circumstances or state of mind that preceded her death. The surviving family, in the wake of these 3 deaths, is documented no further in the sources reviewed. Frank Squire and Edward Squire, having been cleared of suspicion through their respective alibis, do not appear again in the record beyond the conclusion of the original investigation, nor does George Niblett, whose connection to the family through his courtship of Christiana Squire would presumably have been severed by her death. George Squire, the 17-year-old grandson who gave testimony at the inquest, likewise disappears from the documentary record once his evidence had been heard. The absence of further documentation regarding the fates of these individuals is consistent with the general pattern of Victorian criminal records, in which witnesses and family members connected to a case typically appear only for the duration of their direct involvement in the investigation or inquest, their subsequent lives passing unrecorded except where some later event, such as Thomas Wright's false confession 16 years afterward, brought the case, and by extension its surviving connections, briefly back into public view. The shop at 46 Hyde Road, the scene of the murders, does not appear to have retained any particular notoriety within the physical landscape of Hoxton beyond the period immediately following the crime, at least so far as the surviving record indicates. No account describes the premises being avoided by prospective tenants or acquiring a reputation of the kind sometimes attached to sites associated with notorious violence elsewhere in London. This absence of any documented afterlife attached to the physical location itself is consistent with the case's broader classification as one preserved chiefly through documentary and archival means, rather than through popular tradition or local memory carried forward across generations. The 3 cleared suspects, taken together, illustrate a recurring feature of Victorian murder investigations conducted within close-knit family and community settings, in which the process of elimination through alibi served as the primary tool available to investigators in the absence of forensic evidence capable of identifying a perpetrator independently of witness testimony. Each of the 3 men investigated in connection with the Squire murders, Frank Squire, Edward Squire, and George Niblett, was cleared not through any positive evidence of innocence beyond the establishment of his whereabouts at the relevant hour, a method of investigation that, while sound as far as it went, offered no means of identifying an alternative suspect once the family's own circle had been exhausted. It was this limitation, common to police investigations of the period working without fingerprint analysis or other forensic techniques that would only become available in subsequent decades, that left the case formally unsolved, despite the sustained effort represented by the scale of the reward offered and the number of witnesses examined across the 3 sessions of the inquest. The documentary record of the Squire case, preserved across contemporary press accounts and later archival compilations, has proven of particular value to those researching the practical operation of Victorian police investigation, precisely because of its thoroughness in the face of ultimate failure. Few cases of this period preserve so complete a roster of named witnesses, drawn as they are from across the trades and households of a single street, together with the names of the officers who conducted the inquiry and the coroner and deputy coroner who presided over its formal examination. This completeness allows the case to serve, within the specialist literature devoted to Victorian crime, as an illustration of the investigative methods available to the Metropolitan Police during this period. Methods that relied heavily upon the systematic canvassing of a neighbourhood, the taking of statements from all persons who might plausibly have observed something of relevance, and the elimination of suspects through the verification of their movements against the known or estimated time of the crime. The case's classification as unsolved has not, in the years since 1872, been altered by any subsequent development beyond the false confession offered by Thomas Wright in 1888, itself conclusively dismissed rather than confirmed. No later re-examination of the case is documented as having produced a new suspect or a revised understanding of the events of the 10th of July, and the verdict returned by the coroner's jury at the conclusion of the inquest. Willful murder against some person or persons unknown remains the final formal determination entered into the historical record. The case has, in this respect, retained its status as an open file in the fullest sense, one in which the documentary record permits a detailed reconstruction of the crime, the investigation, and the inquest, while the identity of the person responsible for the deaths of Sarah and Christiana Squire remains to this day entirely unknown. The wider pattern of unsolved violent crime within London's East End during the middle decades of the 19th century forms a general backdrop against which the Squire case may be understood, though the specific circumstances of this case, a ransacked shop, a family with an institutionalised member, a courting suitor, and a false confession emerging more than a decade and a half later, distinguish it from the broader run of such cases through the particular richness of its surviving documentation. The district's dense settlement, its reliance on small trade conducted from premises that combined commercial and domestic space under a single roof, and its population of tradesmen and labourers known to one another across overlapping streets and occupations, together created the conditions within which a crime of this nature could occur in full view, in a sense of a community whose members nonetheless proved unable, despite their collective testimony, to identify the individual responsible. The premises at 46 Hyde Road, as reconstructed through the surviving testimony, would have presented to any visitor arriving in the ordinary course of business a shopfront cluttered with the stock of the picture and print trade, prints stacked or displayed for the inspection of customers, the counter behind which Sarah Squire was accustomed to conduct her transactions, and the passage leading to the private rooms in which she and her daughter lived, apart from the demands of the shop. It was within this arrangement of commercial and domestic space, so common to the small trading premises of Victorian London, that the violence of the 10th of July occurred, leaving Sarah Squire's body behind the counter where her daily work had been conducted, and Christiana Squire's body divided between the passage and the parlour, a physical distribution of the two women's remains that has itself become, within the documentary record of the case, one of its most concretely established and most frequently noted details. No arrest was ever made. The investigation was formally closed. The case remains open. The record remains incomplete. That record, too, was closed without a name attached to it, and the file that held it was set aside much as the one before it had been. We turn now to the last of these three cases, the most obscure of the three, and in many respects the most quietly unsettling, for it concerns a woman who wanted for nothing in the material sense, and who was nonetheless left dead in her own kitchen by a hand that was never identified. It unfolded not in the crowded lanes of the East End, but in one of the more genteel corners of London, a short walk from two of the capital's great railway termini, in a household that had every outward appearance of comfort and safety. The question it left behind was not so very different from the ones that came before it. The case of Rachel Samuel begins in Bloomsbury, London, in December of 1878. Rachel Samuel was an elderly widow who resided alone, with the assistance of domestic help at 4 Burton Crescent, a substantial terraced townhouse in a fashionable residential crescent laid out some 7 decades earlier. By 1878, London had grown into the largest city in the world, with a population exceeding 4 million persons spread across an ever-expanding ring of parishes, boroughs, and outlying districts. Bloomsbury, situated to the north of the ancient city, and to the east of the fashionable squares of Marylebone, had by this date long been established as a district of settled respectability, favoured by professional families, university men, and persons of independent means who preferred its quiet garden squares to the noise of the commercial thoroughfares nearer the river. The crescent in which Rachel Samuel resided, Burton Crescent, had been developed between 1809 and 1811 by the builder James Burton, a man responsible for a considerable portion of Bloomsbury's residential expansion during the early years of the 19th century, working under the terms of the Skinner's Company estate. The crescent's design followed the fashionable pattern of the period, a sweeping curve of terraced houses in stuccoed brick, each with a front area and railings, a raised ground floor reached by a short flight of steps, and a rear yard giving onto a mews or service lane. Such houses were built to accommodate not merely a single family, but the servants required to maintain a household of that class, and it was common in a crescent of this kind for individual houses to retain 1, 2, or occasionally 3 domestic servants, depending on the means of the occupant. By the final decades of the Victorian era, Burton Crescent had begun to show the layered character common to many such developments as they aged. Some houses remained in the occupation of families of considerable means, their households run along traditional lines with cooks, housemaids, and general servants. Others had been subdivided into lodgings, let by the room or by the floor to persons of more modest circumstances, a pattern that would become still more pronounced in the Crescent in the years that followed. The street lay within easy reach of Euston Station, opened some 4 decades earlier, and King's Cross Station, opened in 1852, both termini bringing a constant traffic of travellers, porters, and cab drivers through the surrounding streets at all hours. The presence of 2 great railway stations within a short walk of a residential crescent was not thought remarkable by the standards of the district, though it did mean that Burton Crescent, for all its outward gentility, was never entirely removed from the passing traffic of a great city. Domestic life in a household such as Rachel Samuel's followed a settled pattern common across the middle and upper middle classes of the period. The kitchen, typically situated in the basement or at the rear of the ground floor, formed the working heart of the house, the place where meals were prepared, where coal and provisions were brought in by the area steps, and where a resident or daily servant would ordinarily spend the greater part of her working hours. It was in December, at the approach of Christmas, that households of this kind saw a marked increase in the volume of provisions kept on the premises, in coal laid in against the cold, and, in some households, in ready money kept close at hand to meet the seasonal demands of tradesmen, servants' wages, and Christmas gratuities. It was into this setting, an elderly widow's household in a respectable Bloomsbury Crescent at the approach of the Christmas season, that the events of December 1878 fell. Rachel Samuel is described in the surviving record as an elderly widow of comfortable means. The record does not establish her precise date or place of birth, the names of her parents, or the circumstances of her early life, and no reliable account of her upbringing or education has been preserved. She is likewise not documented in the surviving sources as to the name or occupation of her late husband, nor as to the date of his death, though her status as a widow of independent means by 1878 indicates that she had been left, whether through inheritance, settlement, or her own management of affairs, in a position of financial security sufficient to maintain a household of her own in a fashionable part of London. She is recorded as having been in possession of valuable jewellery and a substantial sum of money kept within the house, a detail consistent across the accounts that survive, and one that speaks plainly to her standing as a woman of some property, whatever the particulars of how that property had come to her. The record does not establish the number of years Rachel Samuel had resided at 4 Burton Crescent prior to December 1878, nor does it establish whether she had lived elsewhere in London or in another part of the country before taking up residence there. What the record does establish is that she had, at some point prior to the events of that December, employed a servant by the name of Mary Donovan. The nature and duration of that employment, and whether Mary Donovan remained formally in Rachel Samuel's service at the time of the murder, or had by then left the household, is not established with certainty in the surviving accounts, and the point must be treated as unresolved. What is clear is that Mary Donovan possessed, by virtue of her prior service in the house, a knowledge of its arrangements, its inhabitants, and its contents that few outside the household would have shared. It was this knowledge, whatever the precise state of her employment at the time, that would draw the attention of investigators once the crime became known. The absence of a fuller documented early life for Rachel Samuel is not unusual for a woman of her generation and situation. Women of independent means who lived quietly, without public office, without publication, and without the kind of civic or philanthropic prominence that drew notice in the newspapers of the day, frequently left behind little trace beyond the bare facts of their residence, their household, and, where it occurred, the manner of their death. Rachel Samuel's case is of this kind. The record that survives concerning her life prior to December 1878 is confined almost entirely to her status as an elderly widow, her residence at 4 Burton Crescent, and her evident financial comfort. It is upon this narrow foundation, and upon the fuller record of the crime itself and the investigation that followed, that the account of her case must rest. The circumstances leading up to the crime, so far as they are documented, concern chiefly the household itself and its vulnerabilities. Rachel Samuel lived alone at 4 Burton Crescent, a phrase which, in the domestic arrangements of the period, ordinarily meant that she maintained the household without a resident husband, adult son, or other male relative in permanent occupation, though she would, in the ordinary course of things, have retained the services of at least one servant to assist with the daily management of the house. A widow living alone in this manner, however comfortable her means, occupied a position that was in certain respects exposed. She was known, or at least understood within her own circle, and evidently within the wider household, to keep valuables and ready money on the premises, a practice common among persons of her generation who had not fully adopted the newer custom of depositing surplus funds with a bank. Such a practice, however customary, carried with it an evident risk where the extent of those valuables was known to persons outside the immediate family, including present or former domestic servants. It is at this point that the figure of Mary Donovan enters the record most significantly. As a former servant of the household, Mary Donovan would have possessed knowledge of the layout of the house, the habits of its owner, and, in all likelihood, some understanding of where money and valuables were customarily kept. Whether she retained any ongoing connection to the household in the weeks or months preceding December 1878, whether by way of occasional employment, social visits, or simple proximity within the same part of London, is not established in the surviving accounts. Investigators in the aftermath of the crime evidently regarded her prior service and her resulting knowledge of the household as sufficient grounds for suspicion, a pattern of reasoning entirely consistent with the investigative habits of the period, in which domestic servants, present and former, were routinely and often disproportionately regarded as the most probable suspects in crimes committed within a private household. No other documented stresses, disputes, or unusual occurrences within the household in the period immediately preceding the murder have been preserved in the sources reviewed, and the record must be understood as silent on these points, rather than as establishing that no such circumstances existed. The reflective position at this stage of the record is a narrow one. What can be said is that Rachel Samuel was an elderly widow of independent means, living alone but for domestic assistance in a respectable Bloomsbury Crescent, at a time of year when households of her kind customarily kept increased sums of ready money on hand. What can also be said is that she had, at some point, employed as a servant a woman named Mary Donovan, whose knowledge of the household would later draw the attention of investigators. Beyond these bare facts, the circumstances of Rachel Samuel's life in the weeks and days before her death are not established in the surviving record, and no further detail may be responsibly supplied. It was in December 1878, in the days approaching Christmas, that Rachel Samuel was killed within her own house. The precise date of the murder is not established with certainty in the surviving accounts, and the record available for this account does not permit a specific day to be stated as fact. What is documented is that the crime occurred at night, within the household at 4 Burton Crescent, and that the location of the attack, according to the fuller modern account of the case, was the kitchen at the rear of the house, the room in which a servant would ordinarily have carried out the greater part of her daily work, and in which household stores and, on occasion, money and small valuables might reasonably be found. Rachel Samuel was beaten to death. The surviving record does not establish the specific implement used, nor does it provide a detailed clinical account of the injuries inflicted, and none is required to establish that the attack was severe and rapidly fatal. She did not survive the assault. According to the account most consistently corroborated across the modern sources reviewed for this record, a number of items were taken from the house at the time of the murder, including Rachel Samuel's wedding ring, a quantity of coins, and a pair of her boots. The taking of these particular items, personal in nature and of a kind that would have been readily to hand within the house, rather than locked away, is consistent with a crime carried out by a person already familiar with the household and its arrangements, rather than by a stranger acting without prior knowledge of where valuables might be found. It is this circumstance, taken together with her prior service in the house, that appears to have directed the earliest suspicion of investigators toward Mary Donovan. The record available for this account should be understood as resting on this version of events, in which specific items were removed from the house, rather than on an alternative and less well corroborated tradition, suggesting that nothing was disturbed and that the motive for the crime remained wholly obscure. Where sources conflict in this manner, the better attested account has been preferred, and the record does not attempt to reconcile the two. The discovery of Rachel Samuel's body is not documented in the surviving sources with any particularity as to who first found her, at what hour, or under what immediate circumstances. It may be observed as a matter of the general practice of the period that a household of this kind, in which a servant or servants attended daily or resided on the premises, would ordinarily have come to the discovery of such a crime in the course of the household's usual morning routine. When a failure of the mistress of the house to appear, or an unusual silence within the house, would have prompted a servant or a neighbour to investigate further. No such specific account, however, survives in the record reviewed for this case, and the matter of discovery must be regarded as one of the points at which the surviving documentation is silent rather than informative. What is established is that the body was found, that the crime became known to the authorities, and that an investigation was in due course formally opened into the death of Rachel Samuel of 4 Burton Crescent, Bloomsbury. The reflective position at the close of this stage of the record is that Rachel Samuel, an elderly widow living alone but for domestic assistance in a respectable Bloomsbury household, was beaten to death within her own house in December 1878 in circumstances that pointed, through the taking of personal items readily to hand, toward a perpetrator already familiar with her household. The precise date, the identity of the person who discovered her, and the immediate circumstances of that discovery are not established with certainty in the surviving record. What followed was the formal opening of a police investigation, an investigation that would in due course settle its attention upon a single named suspect without ever securing sufficient evidence to bring that suspicion to trial. The investigation into the death of Rachel Samuel was formally opened by the Metropolitan Police in the days following the discovery of her body, in keeping with the established procedure for a sudden and violent death occurring within the Metropolitan Police District. Officers were dispatched to 4 Burton Crescent to examine the scene, a standard first step in any case of this kind, intended to establish the position and condition of the body, the state of the room in which the crime had occurred, and the presence or absence of any signs of forced entry. The surviving record does not preserve a detailed account of what was observed by the officers upon their arrival, beyond the general facts already given, namely that the attack had occurred in the kitchen and that certain items, including a wedding ring, a quantity of coins and a pair of boots, were found to be missing from the house. In the absence of any indication that entry had been forced, whether through a broken window, a damaged door, or disturbed fastenings, investigators were led toward the conclusion that the person responsible had either been admitted to the house, had possessed some existing means of access, or had entered through an opening left unsecured by an occupant of the house itself. This line of reasoning was consistent with the wider pattern of the case, in which the items taken were of a kind readily to hand rather than concealed, and in which the household's own domestic arrangements appeared to bear directly upon how the crime had been possible at all. Statements were taken from those persons who could speak to the household's recent circumstances, its arrangements for admitting servants and tradesmen, and its usual routine in the days preceding the murder. The surviving record does not preserve the names of those interviewed beyond the eventual focus of suspicion, nor does it preserve the substance of their statements in any detail. It may be said only that the process of taking statements from neighbours, tradesmen, and any servants then in or recently connected with the household would have followed the standard practice of a Metropolitan Police investigation of the period, in which officers move systematically through those persons with any plausible connection to the deceased or her house, seeking to establish who had last seen her, who had last been admitted to the premises, and whether any person had been observed in the vicinity of Burton Crescent in the days or hours before the crime became known. It was through this process of inquiry, whatever its precise course, that the attention of investigators came to settle upon Mary Donovan, the former servant of the household. Her prior service in the house, and the knowledge of its contents and arrangements that such service would necessarily have afforded her, appear to have been the principal grounds upon which suspicion was directed toward her rather than toward any other person. The taking of items readily to hand, including a ring, coins and boots, was consistent with the actions of a person already acquainted with where such items might be found, and with the general habits of the household, a consideration that would have weighed heavily with investigators accustomed to the recurring pattern common across many such cases of the period, in which crimes committed within a private house were frequently traced to a servant, present or former, rather than to a stranger. Mary Donovan was in due course arrested on suspicion of the murder of Rachel Samuel. The surviving record does not establish the precise date of her arrest, nor does it preserve the specific evidence or line of reasoning presented by investigators at the time she was taken into custody. What is documented is that she was arrested, that she was held on suspicion in connection with the crime, and that she was subsequently released, the case against her having been found insufficient to warrant her committal for trial. No further named suspect is documented in the surviving accounts of this case, and no other person is recorded as having been arrested, questioned under formal caution, or otherwise brought within the scope of the investigation in any manner comparable to Mary Donovan. The release of Mary Donovan for insufficient evidence indicates that whatever grounds had directed suspicion toward her, whether her prior knowledge of the household, her opportunity to have been present, or some other circumstance not preserved in the record, fell short of what the law required to sustain a formal charge. Insufficient evidence within the practice of the period meant that the case, as investigators had assembled, it did not meet the threshold necessary to justify committal proceedings before a magistrate, still less a trial at the Old Bailey, London's Central Criminal Court. It did not mean that Mary Donovan was thereby cleared of all suspicion in the eyes of the investigating officers or of the wider public, only that the evidence gathered against her could not be relied upon to secure a conviction, and that the investigation, having exhausted this line of inquiry, was left without a case it could bring before a court. The investigation, having arrested and released its principal suspect, appears from the surviving record to have made no further substantial progress. No additional suspect is documented as having been identified, arrested, or seriously investigated in connection with the murder of Rachel Samuel. The record does not preserve any account of continued police activity in the weeks or months following the release of Mary Donovan, nor does it preserve any indication that the case was reopened at a later date on the strength of new evidence or a fresh confession. The investigation, in the form in which it survives in the historical record, appears to have concluded with the release of its one named suspect and with no further resolution. The reflective position at the close of the investigative stage of this case is a narrow one. Officers were dispatched to the scene, statements were taken, and suspicion settled upon a former servant of the household whose prior knowledge of its arrangements appeared to investigators to be significant. That suspect was arrested and subsequently released for insufficient evidence. No other suspect is documented, and the investigation, so far as the surviving record establishes, did not proceed further. The medical examination of Rachel Samuel's body was conducted in accordance with the standard procedure of the period for any sudden and violent death occurring within the Metropolitan Police District. A physician would ordinarily have been summoned to the scene at the earliest opportunity, both to confirm that life was extinct and to form an initial impression of the nature and severity of the injuries before the body was removed for a fuller post-mortem examination. The surviving record for this case does not preserve the name of the examining physician, nor does it preserve the specific findings recorded at post-mortem beyond the general fact that Rachel Samuel had died as the result of a severe beating. The examination would, in the ordinary course, have sought to establish the cause of death, the general character and severity of the injuries sustained, and an approximate estimate of the time at which death had occurred, information that would, in turn, have been presented to the coroner's inquest, convened to inquire formally into the death. What may be stated with confidence, notwithstanding the absence of a named physician or a detailed post-mortem record, is that the injuries sustained by Rachel Samuel were severe and rapidly fatal, consistent with a sustained and violent attack rather than a single blow or an accidental injury. A cause of death of this kind, once established by medical examination, would ordinarily have been reported to the coroner in the form of a formal medical certificate or testimony given at the inquest itself, and it is through this mechanism, rather than through any surviving independent medical record, that the fact of a severe and fatal beating has come down as part of the documented account of the case. No further clinical detail is preserved in the sources reviewed, and none may responsibly be supplied beyond what has already been stated. The reflective position on the medical stage of the case is accordingly brief. A physician would have examined the body, established the cause of death as resulting from a severe beating, and reported these findings in due course to the coroner. Beyond this, the surviving record does not permit further particulars to be stated as established fact. An inquest into the death of Rachel Samuel would, in keeping with the universal practice of the period, have been convened before a coroner and a jury, the standard mechanism by which any sudden, violent, or unexplained death within the jurisdiction of the Metropolitan Police District was formally inquired into such an inquest would ordinarily have been held within a matter of days of the discovery of the body, at a public house, parish hall, or other suitable premises in the vicinity of Burton Crescent, this being the customary venue for coroner's proceedings in London throughout the 19th century. The jury, composed of local residents, would have heard testimony from those able to speak to the discovery of the body, from the examining physician as to the cause of death, and from investigating officers as to the state of the inquiry at the time the proceedings were held. The surviving record does not preserve the name of the coroner who presided over the inquest into the death of Rachel Samuel, nor does it preserve the specific testimony given by any witness who appeared before the jury, nor the precise date upon which the inquest was held or concluded. It may be observed, as a matter of the general practice of coroners' inquests during this period, that where an investigation had not yet concluded, or where a suspect remained under active suspicion, without sufficient evidence to justify committal, a coroner's jury would frequently return a verdict of willful murder against some person or persons unknown, a formal finding that established the fact of unlawful killing while leaving the identity of the killer formally unresolved. Whether such a verdict was in fact returned in the case of Rachel Samuel is not established with certainty in the surviving sources, and the record available for this account does not permit the specific wording of the inquest's verdict to be stated as fact. What may be said with confidence is that an inquest would have been convened, that it would have heard evidence as to the cause of death and the circumstances of the discovery of the body, and that its proceedings would have taken place against the backdrop of an investigation that had, by that point or shortly thereafter, arrested and released its principal suspect without securing sufficient evidence to proceed further. The inquest, whatever its precise findings, did not result in any person being committed for trial in connection with the death of Rachel Samuel. The reflective position at the close of the inquest stage is that a formal inquiry into the cause of death was convened before a coroner and jury in keeping with standard practice, and that it did not result in any person being charged or committed for trial. The precise date, presiding coroner, and specific verdict returned are not established in the surviving record, and the case must be understood, at this stage, as one in which the formal machinery of inquiry was set in motion without arriving at a resolution. No trial took place in connection with the death of Rachel Samuel. Mary Donovan, the one person arrested on suspicion of the murder, was released before any committal proceedings could bring the matter before a magistrate with a view to trial at the Old Bailey or at the Middlesex Sessions. No other person was at any time charged, committed, or brought to trial in connection with this case. The absence of a trial is itself a significant fact in the record of this case, distinguishing it sharply from cases in which a named suspect was formally tried and either convicted or acquitted. Here the case did not proceed even so far as a trial, the evidence against the one suspect identified having been judged from the outset insufficient to sustain a prosecution. The absence of any trial record means that no formal legal narrative of the crime, of the kind ordinarily produced through the examination and cross-examination of witnesses before a jury, survives for this case. What is known of the crime, the investigation, and the release of Mary Donovan rests instead upon the more fragmentary record preserved in contemporary press summaries, in later archival compilations of unsolved London murders, and in a small number of retrospective accounts of the case published in the years following. No sentence was passed because no verdict was returned, because no trial was held, because no person was ever formally charged. No sentencing followed, for the same reason. No execution, imprisonment, or other punishment was ever carried out in connection with the death of Rachel Samuel, since no conviction was ever secured against any person. The case remained, from the point of Mary Donovan's release onward, a matter of unresolved suspicion rather than established legal fact, and it is in these terms as an unsolved case in which the identity of the true perpetrator was never established that the historical record has preserved it. The reflective position on the outcome of this case is accordingly a plain one. No trial was held, no sentence was passed, no person was ever convicted of the murder of Rachel Samuel, and the question of who killed her in her own kitchen in the days approaching Christmas of 1878 was never formally answered by any court. The later life of Mary Donovan, following her release from custody, is not documented in the sources reviewed for this case. No record survives of where she resided thereafter, what occupation she pursued, or how long she lived following the events of December 1878. The record available for this account does not establish her fate beyond the fact of her arrest and subsequent release, and no further detail may responsibly be supplied. The absence of any further documentation concerning Mary Donovan is consistent with the general pattern of this case, in which the surviving record is confined almost entirely to the bare facts of the crime, the investigation, and its inconclusive outcome, with little preserved concerning the lives of those involved before or after the events of December 1878. This narrowness of record is itself a notable feature of the case, distinguishing it from more extensively documented crimes of the period in which the subsequent histories of suspects, witnesses, and investigating officers were more fully preserved in the press or in later legal and historical accounts. The case of Rachel Samuel is documented in the surviving record chiefly within general compilations of unsolved London murders, of the kind assembled by later archivists and historians seeking to catalogue those Victorian crimes that were never brought to a legal resolution. It appears within such a listing alongside numerous other cases from the same period, each identified by the name of the victim, the approximate date, and the bare circumstances of the crime, with the case of Rachel Samuel distinguished chiefly by its location at Burton Crescent and by the arrest and release of Mary Donovan as the one named suspect. Beyond this archival presence, the case is also recorded in at least one retrospective volume concerning notable or sinister crimes of London's past, published in the early years of the 20th century, a type of publication common in the period, which gathered together accounts of unsolved or otherwise memorable crimes for a general readership with an appetite for the darker corners of the capital's history. The case did not, so far as the surviving record establishes, generate the kind of sustained cultural attention that attached itself to some of the more notorious unsolved crimes of the Victorian period. No novel, stage adaptation, or later dramatic treatment is documented as having taken the case of Rachel Samuel as its subject, and no legal precedent or point of criminal procedure is recorded as having arisen from the investigation or its conclusion. Its persistence in the historical record has been of a quieter kind, preserved chiefly by those compilers and historians whose work has been concerned with recovering the full range of Victorian London's violent crime, including those cases that commanded no lasting public fame, but that nonetheless left behind a documented victim, a documented suspect, and a documented failure to resolve the question of guilt. It is in connection with the physical setting of the crime, rather than with any literary or dramatic afterlife, that the case of Rachel Samuel possesses its most durable and verifiable legacy. Burton Crescent, the street on which she had resided and in which she was killed, underwent a formal change of name in the year 1908 when it was renamed Cartwright Gardens, the name by which the street remains known. The renaming is documented as having been connected, at least in part, to a desire on the part of residents and local authorities to distance the street from its association with unsolved violent crime, a category in which the case of Rachel Samuel was not the only entry, for Burton Crescent had also been the scene of a separate and distinct murder some years later in 1884 at a different address on the same street, involving a different victim and different circumstances entirely unconnected to the case of Rachel Samuel. The renaming of the street is also documented as having honoured the political reformer John Cartwright, a resident associated with the area in an earlier period, so that the change of name in 1908 appears to have served a double purpose, commemorating a local figure of historical significance, while also, in the practical effect it achieved, allowing the street to shed a name that had, by the early 20th century, become associated in the public mind with more than one unresolved and violent death. The social and historical context in which the case of Rachel Samuel unfolded was that of a solidly middle-class residential district of London in the final decades of the 19th century, a district whose crescents and squares housed professionals, retired persons, widows of independent means, and the domestic servants who attended them. Bloomsbury of this period stood in marked contrast to the more crowded and impoverished districts of the East End, its streets wider, its houses larger, its residents drawn overwhelmingly from the ranks of the comfortable middle classes rather than from the labouring poor. Yet the case of Rachel Samuel illustrates a vulnerability that was not confined to the poorer districts of the capital, namely the exposure of a woman living alone, however comfortable her means, to those within her own household or former household who possessed knowledge of her arrangements and her property. The pattern by which suspicion in such cases fell upon a servant, present or former, was a recurring feature of Victorian domestic crime, reflecting both the genuine frequency with which domestic servants were implicated in crimes against their employers, and the readiness of investigators and the public alike to look first within the household itself when a crime of this kind occurred. The historical legacy of the case of Rachel Samuel is accordingly a modest one, confined to its presence within archival listings of unsolved London murders, and to the more concrete and verifiable legacy of the 1908 renaming of the street on which she died. No lasting impact upon law, policy, or the practice of criminal investigation is documented as having flowed from her case specifically, and it is remembered today, where it is remembered at all, chiefly within specialist and archival contexts, rather than in the wider popular memory that has attached itself to some of the more notorious unsolved crimes of the Victorian period. It stands nonetheless as a documented instance of a case in which an elderly widow of comfortable means was killed within her own home, in which suspicion settled upon a single named individual without ever producing sufficient evidence to bring that suspicion before a court, and in which the question of responsibility was left, as it remains in the historical record today, formally unanswered. The house at 4 Burton Crescent itself, like its neighbours along the curve of the crescent, would have continued in residential use in the years following the murder, its rooms let or occupied by successive tenants, with little, if any, outward indication of the events of December 1878 attaching itself to the building. This too was a common feature of Victorian London, in which houses that had been the scene of violent and unresolved crimes were rarely marked or distinguished in any physical sense, but were absorbed back into the ordinary rhythm of the street, let and re-let, bought and sold, their histories preserved only in the documentary record rather than in any visible feature of the building itself. The Crescent's eventual renaming in 1908 stands as the one clear exception to this pattern, an instance in which the accumulated weight of more than one unresolved violent death upon a single street appears to have contributed, however partially, to a formal act of civic erasure, the substitution of a new name for an old one. The domestic service pattern evident in this case, in which a former servant's knowledge of a household's arrangements became the basis of formal suspicion, was not unique to Rachel Samuel's case, but reflected a broader feature of the relationship between employer and servant in Victorian London. A servant, whether resident within the household or attending daily, occupied a position of considerable intimacy with respect to the domestic arrangements of her employer, privy to the location of valuables, the habits of the family, and the times at which the house might be left unattended or its occupants most vulnerable. This intimacy, while essential to the functioning of a household of the period, also rendered servants, present and former alike, the natural first object of suspicion whenever a crime occurred within a private house, a pattern of investigative reasoning that recurs across many documented cases of the period and that shaped the course of the inquiry into Rachel Samuel's death from its earliest stages. The case of Rachel Samuel, considered as a whole, presents a documentary record markedly thinner than is typical of the more extensively reported crimes of the period, a fact attributable in part to the absence of any trial and in part to the more general obscurity into which the case appears to have settled within a relatively short time of its occurrence. What survives is a bare but consistent account. An elderly widow of independent means, killed by beating within her own home in December 1878, robbed of a ring, a quantity of coins, and a pair of boots. A former servant arrested on suspicion and subsequently released for insufficient evidence, and no further resolution ever reached. It is a record of documentation rather than of narrative, a case file rather than a story with a settled ending, and it is in these terms, as a case that was opened, investigated, and never closed, that it has been preserved. The manner in which the case of Rachel Samuel would have reached the wider public in December 1878 followed the standard pattern of Victorian crime reporting, in which the London daily and weekly press carried brief notices of violent deaths within the metropolis as they became known to the police, followed in due course by fuller reports of any inquest proceedings and any subsequent arrest. A case of this kind, involving an elderly widow of evident means killed within a respectable Bloomsbury household, would have attracted a measure of local interest precisely because it departed from the more familiar pattern of violence associated in the public mind with the poorer districts of the East End or the riverside parishes. The killing of a woman of comfortable circumstances within a house of the kind more commonly associated with quiet domestic security than with violent crime, carried its own particular note of disquiet for readers of the period, a disquiet compounded by the fact that the household in question had, or was believed to have had, sufficient means to render it an object of interest to those who might wish to steal from it. The arrest of Mary Donovan would, in the ordinary course of such proceedings, have been reported in the press at the time it occurred, followed by a further report at the time of her appearance before a magistrate, this being the standard procedure by which a person arrested on suspicion of a serious crime was brought before the bench to determine whether sufficient evidence existed to justify her committal for trial. A hearing of this kind, held before a police magistrate at one of the metropolitan police courts, would have involved the presentation of such evidence as the police had then assembled, together with any statement Mary Donovan herself chose to make, or to decline to make, this being her right under the procedure of the period. It was at such a hearing, or in the course of continued investigation following her initial appearance, that the case against her appears to have been found wanting, resulting in her discharge rather than her committal for trial at the Old Bailey or at the Middlesex Sessions. The discharge of a suspect at this stage of proceedings, rather than at a later trial, was not an unusual outcome in cases of the period where suspicion rested upon circumstantial grounds, such as prior knowledge of a household's arrangements, without the support of direct evidence connecting the accused to the crime itself. The standard required for committal, while less exacting than that required for conviction at trial, nonetheless demanded that a magistrate be satisfied that a prima facie case existed, sufficient to justify putting the accused upon her trial before a jury. Where the evidence assembled by the police amounted to little more than the fact of prior service in the household and the resulting opportunity for knowledge of its arrangements, without any further evidence placing the accused at the scene at the material time or connecting her directly to the items taken, a magistrate might reasonably decline to commit the case for trial, precisely the outcome that appears to have occurred in the case of Mary Donovan. The absence of any further named suspect following Mary Donovan's discharge reflects the more general difficulty faced by investigators in cases of this kind, where the principal line of inquiry, once exhausted, left no clear alternative avenue to pursue. Without eyewitness testimony placing any other individual at or near 4 Burton Crescent on the night in question, and without the recovery of any of the stolen items in a manner that might have led to a further suspect, the investigation appears to have reached a natural limit, a point beyond which the resources and methods available to the Metropolitan Police of the period could not carry the inquiry further. This, too, was a recurring pattern in the unsolved crimes of Victorian London, in which an initial and often reasonable suspicion, once tested and found insufficient, left behind no clear path toward an alternative resolution, and the case passed, by default rather than by any formal decision to abandon it, into the category of those crimes that remained permanently unresolved. The household at 4 Burton Crescent, in the aftermath of Rachel Samuel's death, would in the ordinary course have passed to whatever heirs or executors were named in her will or entitled under the law of intestacy, then in force, the property and remaining contents of the house being administered according to the standard legal procedure of the period for the estate of a deceased widow. The surviving record does not preserve the name of any executor, heir, or relative who came forward in connection with Rachel Samuel's estate, nor does it preserve any account of the disposition of the house itself in the years immediately following her death. It may be observed only that the Crescent itself continued in ordinary residential use, its individual houses passing between owners and tenants in the years that followed, in keeping with the general pattern of a fashionable London street entering the later decades of the 19th century. The wider pattern of unsolved violent crime within the Metropolitan Police District during this period was not confined to the case of Rachel Samuel, and a number of other killings of women during the 1870s and 1880s occurring under broadly comparable circumstances of robbery within a private residence, similarly failed to result in a conviction, notwithstanding the identification of one or more persons as suspects in the course of investigation. This pattern, in which suspicion was raised, tested, and found insufficient without any alternative resolution being reached, reflects less upon any particular deficiency in the investigation of Rachel Samuel's death specifically than upon the more general limitations faced by police investigators of the period in cases lacking direct eyewitness evidence or a confession, limitations that affected the investigation of violent crime across the metropolis, regardless of the social standing of the victim or the district in which the crime occurred. Bloomsbury's own character during the years immediately following the murder continued along the lines already established. A district of settled middle-class residents, increasingly overshadowed in the public imagination of London crime by the more sensational violence associated with the East End in the following decade, violence that would in time overshadow entirely the memory of quieter, earlier cases, such as that of Rachel Samuel. The Crescent itself, renamed in 1908, entered the 20th century under its new designation. Its earlier association with 2 separate unresolved killings gradually receding from public memory, even as the bare facts remain preserved within the archival record from which this account has been drawn. The reflective position on the case of Rachel Samuel, considered now in its entirety, is that of a documented crime without a documented resolution. An elderly widow of independent means was killed within her own household in December 1878. A former servant was arrested on suspicion and discharged for insufficient evidence. No other suspect was ever identified, no trial was ever held, and no person was ever convicted of her murder. The street on which she died was renamed 30 years later, a change that served in part to honour a local historical figure, and in part, according to the documented account, to distance the Crescent from its association with unresolved violence. The case remains within the archival record of London's unsolved crimes, exactly where it was left in the closing months of 1878, a file without a final entry. The case of Rachel Samuel was the last of these 3 cases to enter the historical record. The case file was closed without resolution. No suspect was charged. The record remained as it stood.